Hi, I'm Mike Steger. I'm a trademark and copyright attorney. And yesterday I was talking to a marketing professional and she asked, what's your process for obtaining a trademark for a client? And I thought, I haven't recorded video on this. So I'm going to give you step by step for what we do at our firm. If somebody comes to try to get a trademark registration. So the first thing we have to do is figure out what's the trademark going to be, what are the words, the design, slogan, possibly something else. And we have to figure out what goods or services are going to be covered by the trademark application, because you have to follow trademark in association with specific goods and services. So after that, we will conduct searches to see if there are conflicting trademarks out there. Start with a search of the USPTO trademark database. Depending on what the client wants to do, we may do broader searches. We may have an outside search firm that we pay to do part of that. We get the search results. We report back to the client. Possibly everything looks clean. Here are some possible conflicts. From these conflicts, how likely is it that that would lead to a refusal of your trademark application? And again, the detail that we go into with the client depends if the client wants to just get a quick report or the client wants a detailed trademark opinion letter, which obviously costs more than a quick report. And after that, we prepare and file the application with the trademark office. Then we wait. Right now, it's taking about 7 months for the trademark office to look at an initial trademark application. And typically, once we file the application, that is where our initial flat fee ends. We usually charge a flat fee for all the work that I just described. Now, after the trademark office looks at the application, they may come back and say, you may need to change some things, change some wording, maybe additional information that needs to be responded, or there may be a refusal on various grounds that we need to give a substantive response to. That typically is work that's paid for by the hour if we're going to respond. If the trademark application is approved, it is then published for opposition by the trademark office. There's a 30-day period that can be extended for possible opposers to come in and oppose the application, saying that it would interfere with their trademark rights. If the application goes through the opposition period, if it was filed on a use in commerce basis where the client was already using the mark, will then go straight to registration. They get their registration certificate, and everyone will live happily ever after, at least for the next 5 to 6 years. If it was filed on an intent to use basis, then at some point the client needs to prove actual use, that they're using the trademark in the United States in association with those goods or services to get the trademark. That's a short rundown of the process for getting a trademark registration. I'm Mike Steger. I'm a trademark and copyright attorney. Be glad to discuss any trademark issues with you.